You want to sue a hospital?" The attorney laughed, not unkindly, but not kindly either. "Honey, you're a home health aide. You don't even have a case number yet. Go home before you embarrass yourself and your daughter." Kwame Asante was 22 years old, standing in the marble lobby of Hendricks & Lowe, one of the most respected medical malpractice firms in Philadelphia, holding a manila folder so thick the edges had started to curl. He had taken 2 buses to get there. He was wearing his stepfather's blazer, which was too wide in the shoulders and smelled faintly of cedar. The receptionist hadn't even offered him a seat. He went home. But he didn't stop. The room Kwame shared with his younger sister Brianna in their grandmother's row house in West Philadelphia was 12 feet by 9. He knew this because he had measured it once, trying to figure out if a second desk would fit. It wouldn't. So he worked on the floor, his back against the radiator, surrounded by printed medical records, pharmacy receipts, and a yellow legal pad filled with notes in his small, precise handwriting. His mother, Kwame Asante, had died 11 months ago at St. Dominic's Medical Center. She was 46 years old. She had gone in for a routine gallbladder removal, a laparoscopic procedure the surgeon had described to Kwame as bread and butter. 4 hours after surgery, Claudette was dead. The official cause listed in the discharge summary was cardiac event, origin undetermined. The hospital had sent a sympathy card signed by the entire surgical floor. It arrived 3 days after they sent the bill. Kwame had cried for exactly 1 week. Then he had started reading. He wasn't pre-law. He wasn't pre-med. He had been enrolled in a 2-year IT certification program at Philadelphia Community College. Before his mother's arrest had swallowed his savings. Before his mother's death had swallowed everything else. What Kwame had was an obsessive, architectural mind. The kind that couldn't accept a closed door without first mapping every hinge, and a grief so bottomless it had calcified into something harder, something useful. He began with the death certificate, then the surgical notes. Then he filed a records request with the hospital under Pennsylvania's Medical Records Act, which entitled him to a full copy of his mother's chart within 30 days. St. Dominic's sent him an invoice for $340 in copying fees and a packet of forms to fill out. He filled out the forms, found a pro bono legal aid office that covered the copying fee, and waited. When the records arrived, all 412 pages of them, Kwame spread them across the floor of that 12 by 9 room and didn't sleep for 36 hours. What he found on page 287 stopped his heart. The anesthesia log showed a 17-minute gap. 17 minutes during which no vitals were recorded for Kwame Asante. The surgeon's post-op notes referenced standard hemostatic protocol. But the nursing notes from the recovery room, filed by a different hand on a different system, described a patient who arrived unresponsive, BP undetectable, pupils fixed and dilated. Someone had already lost her before she ever reached recovery, and the gap in the anesthesia log was the seam where the story had been stitched back together. Kwame took his findings to 3 different attorneys over the next 6 weeks. The first told him the statute of limitations clock was running. The second told him that without an expert witness willing to testify against another physician, no case could proceed in Pennsylvania. The third, a woman named Beverly Cho, who ran a small civil rights practice out of a shared office in Germantown, sat with him for 2 hours, read every page he brought her, and then said, very quietly, that he had found something real. But Kwame, Beverly told him, removing her reading glasses, finding it and proving it are 2 different mountains. St. Dominic's is represented by Carver Whitfield. You know who Carver Whitfield is? He did now. Whitfield was the senior partner at one of the oldest defense firms in the state. He had defended hospitals, pharmaceutical companies, and municipal police departments for 31 years. He had never lost a wrongful death case. Not one. I can try to file a civil complaint on your behalf, Beverly said, but I have to be honest with you. Without a credentialed expert and without the resources to go toe-to-toe with Whitfield's team in discovery, the odds are very long. They will drown us in motions. They will make this expensive and slow and humiliating. That's how they win. Not in court. Before court. Kwame looked at her. File it, he said. The case, Asante v. St. Dominic's Medical Center, was assigned to Judge Renata Eulich in the Court of Common Pleas. It was a wrongful death action. It was also, by every observable metric, a disaster waiting to happen. Whitfield's firm filed 12 pretrial motions in the first 45 days. They moved to dismiss on grounds of insufficient expert certification. They moved to exclude the anesthesia log on chain of custody grounds. They filed a motion challenging Beverly Cho's standing to introduce certain medical evidence without co-counsel, who held a specialized medical malpractice certification. A certification that cost $4,000 to obtain and required 18 months of documented case experience. Beverly didn't have it. Her practice was civil rights, not malpractice. They're not wrong on that one. Beverly told Kwame the night before the first hearing. They were sitting at her small conference table, which was actually a folding table she'd covered with a dark green cloth. I can fight it, but it's going to take time we don't have, and it gives Whitfield a procedural win right out of the gate. Kwame was quiet for a long moment. What if I filed a supplemental motion? As a lay advocate on behalf of the estate. Beverly looked at him carefully. Pennsylvania allows a next of kin to file supplemental briefs in civil matters under limited circumstances. But Kwame, you'd be going up against Whitfield's associates in open court. These are people with law degrees and 10 years of litigation experience. I know, Kwame said. I'm going to need access to your case law database tonight. He found the argument at 2 a.m. It was buried in a 2018 Pennsylvania Superior Court ruling, Garrison v. Allegheny Health Network, that had never been widely cited because it had settled before appeal. In Garrison, the court had ruled that when a hospital's own internal quality review documentation contradicted its public-facing incident reports, those internal documents became subject to mandatory disclosure under the state's Patient Safety Act, regardless of whether they had been flagged as privileged peer review materials by the institution. St. Dominic's had a quality review committee. Every accredited hospital did. That committee was required by state law to convene within 72 hours of any patient death that occurred during or immediately following a surgical procedure. Kwame had the hospital's own accreditation filings, which he had requested from the Pennsylvania Department of Health, listing the committee's standard operating procedures. He cross-referenced those procedures with the timeline of his mother's death. The committee had convened. He could see the notation in a footer on page 3 of 91 of the medical records. A small administrative entry that had clearly been included by accident, the kind of clerical mistake that happened when a 400-page record was assembled in haste. The notation read, QRC Case Review, Asante C. Convened 11/14. Report filed to Risk Management. The report filed to Risk Management had not been included in the records St. Dominic's had sent him. That report existed. And under Garrison, if it contradicted anything in the official surgical notes, which, given the 17-minute gap in the anesthesia log, it almost certainly did, then withholding it was not just an oversight. It was a violation of the Patient Safety Act. It potentially transformed this case from a civil matter into something with criminal implications for the hospital's risk management team. Kwame didn't announce what he had found. He drafted a supplemental discovery motion, citing Garrison, requesting the immediate production of all Quality Review Committee documents related to Claudette Asante's care. He filed it himself as a next-of-kin advocate at 8:47 a.m., 20 minutes before the first hearing was scheduled to begin. The hearing room at the Court of Common Pleas was smaller than Kwame had imagined. Beige walls, fluorescent lights, the smell of burnt coffee drifting from somewhere down the hall. Carver Whitfield sat at the defense table in a charcoal suit that probably cost more than 3 months of Claudette Asante's salary. He was a large man in his 60s, with silver hair, and the settled, immovable confidence of someone who had won so many times that losing had stopped being a real concept to him. He glanced at Kwame once when Kwame entered with Beverly. The glance lasted approximately 1 second. Then Whitfield looked back at his associate and resumed whatever he was saying. Judge Oyalik took the bench. She was a small woman with a direct gaze and no tolerance for preamble. "We're here on defendant's motions to dismiss and to exclude," she said. "Mr. Whitfield, you may proceed." Whitfield stood with the ease of a man who had done this 10,000 times. "Your Honor, the plaintiff's case rests entirely on a gap in an anesthesia log that their own filing admits they cannot explain without expert testimony. Under Pennsylvania Rule of Civil Procedure 1042.3, a certificate of merit signed by an appropriate licensed professional is a threshold requirement. The plaintiff has not produced one. The co-counsel of record does not hold the requisite malpractice certification. Without these elements, there is no case." He sat down. He hadn't used notes. Beverly stood. She argued the certificate of merit question carefully and well. She cited 3 cases. Whitfield's associate objected to 2 of them on grounds of jurisdictional distinction. Judge Oyelek sustained 1 objection. Beverly kept her composure, but Kwame, sitting beside her, could feel the slight shift, the invisible tilting of the room toward Whitfield. Then Judge Oyeleke looked at the docket. "I see there's a supplemental filing from this morning," she said, her voice neutral. "A discovery motion submitted by—" She glanced down. "Mr. Kwame Asante, filing as next of kin advocate for the estate." Whitfield's associate leaned over and whispered something. Whitfield's expression didn't change, but something in his posture went very slightly still. "Mr. Asante," Judge Oyelek said, "you're the decedent's son." Kwame stood. "Yes, Your Honor. You're not an attorney." "No, Your Honor. I'm filing as a supplemental lay advocate under Pennsylvania Rule 2227, which permits next of kin to submit filings in support of estate claims when the interest of justice requires it." Judge Oyeleke studied him for a moment. "Proceed." Kwame kept his voice level. He had practiced this the way other people practiced music, over and over, at different speeds, until it lived in his body, and not just his brain. "Your Honor, this morning I filed a motion under the Patient Safety Act requesting production of the Quality Review Committee report filed by St. Dominic's Risk Management Office on November 14th, 3 days after my mother died. I became aware of this report's existence through an administrative notation on page 391 of the hospital's own medical records production. That report was not included in discovery." "Objection," Whitfield said, still seated, his voice perfectly controlled. "This filing is improper, untimely, and the document referenced is covered by peer review privilege under 63 PS, section 425.4. "Your Honor," Kwame said, "I anticipated that objection, which is why my motion cites Garrison v. Allegheny Health Network 2018, Pennsylvania Superior Court. In Garrison, the court held that when a hospital's internal review documentation potentially contradicts the institution's official incident reporting, peer review privilege is pierced under the Patient Safety Act's disclosure requirements. St. Dominic's official records contain a 17-minute gap in the anesthesia log with no clinical explanation. If the Quality Review Committee found a different explanation, or no satisfactory explanation at all, then that report is directly contradicting the official account of my mother's death. Under Garrison, it must be produced." The room was quiet. Judge Oyelek looked at Whitfield. "Mr. Whitfield, are you aware of the Garrison ruling?" Whitfield's voice was still smooth, but there was a new quality to it. A fraction of something. "Your Honor, Garrison was a superior court decision that was never taken up on appeal. It has limited precedential value and does not apply to. It applies in this jurisdiction until it's overturned," Judge Oyelek said. She looked back at Kwame. "Are you asserting that the Quality Review Committee report was deliberately withheld from discovery?" "I'm asserting that it exists, that it was not produced, and that, under Garrison and the Patient Safety Act, the plaintiff is entitled to it." "What the report contains, Your Honor. That's what the production will tell us." Judge Oyelek set down her pen. She looked at Whitfield with the steady, measuring gaze of someone who has heard a great many excuses in 30 years on the bench and developed an excellent ear for the sound of one forming. "Mr. Whitfield, I'm going to ask you a direct question, and I expect a direct answer. Is there a Quality Review Committee report pertaining to the death of Claudette Asante?" The pause that followed was brief, maybe 3 seconds. But in a courtroom, 3 seconds is a geological age, and everyone in the room felt it. "Your Honor," Whitfield said, "I would need to confer with my client regarding the specifics of their internal documentation." "That is not a direct answer, Mr. Whitfield." Another pause. "I am aware that a standard quality review process was initiated, and the resulting report." Whitfield adjusted his cufflink. "I believe that document may exist within the client's risk management files." Judge Oyelek's expression did not change, but the temperature of the room did. "You believe it may exist," she repeated. "Mr. Whitfield, you filed a motion to dismiss this case on grounds of insufficient evidence. You argued this morning that the plaintiff has no viable claim. Did you review your client's internal documentation before filing that motion?" "Your Honor, our review of the discoverable materials. I asked about the internal documentation." The silence this time was longer. Beverly touched Kwame's arm lightly under the table. He didn't move. He kept his eyes on the judge. "Let the record reflect," Judge Oyelek said, her voice dropping to something very quiet and very final. That defense counsel has acknowledged the existence of a Quality Review Committee report that was not produced in discovery. In a case where the defense simultaneously filed a motion to dismiss for lack of evidence, she picked up her pen. I am denying the motion to dismiss. I am denying the motion to exclude. And I am ordering the immediate production of all Quality Review Committee materials related to Kwame Asante's case within 72 hours. If that production reveals that exculpatory or contradictory information was withheld from this plaintiff, I will be referring this matter to the disciplinary board of the Pennsylvania Supreme Court. Am I understood? Whitfield said, Yes, Your Honor, and his voice for the first time sounded like a voice that was carrying something heavy. The QRC report arrived 41 hours later. Beverly called Kwame at 6:14 in the morning. He was already awake. They found it, Beverly said. Kwame. A pause. The committee concluded that the 17-minute gap in the anesthesia log was the result of an equipment malfunction that had been flagged in 2 prior internal audits. The hospital knew the monitoring system in OR4 had intermittent failures. They hadn't replaced it. They hadn't pulled it from service. They hadn't documented the prior failures in any patient-facing record. And the anesthesiologist assigned to your mother's case had submitted a written complaint about that specific machine 14 months earlier. Kwame sat on the edge of his bed in the 12-by-9 room. Outside, someone was sweeping a front stoop. A car alarm went off 2 blocks away and then went quiet. Knew, he said. They knew, Beverly said. What followed was not a trial. It was a negotiation that lasted 3 weeks, during which Whitfield's firm, representing a client now facing not just civil liability but potential criminal exposure for their risk management team, systematically dismantled its own position. The hospital's board voted to remove the CEO. The anesthesiologist voluntarily surrendered his privileges at St. Dominic's, pending a medical board review. The monitoring equipment in OR4 was pulled from service the same day the QRC report was produced in court. It had been used in 47 surgical procedures since the internal audit first flagged its failures. The settlement was sealed by court order, as the hospital's attorneys insisted, but Beverly Cho told Kwame something else had happened that couldn't be sealed. 3 weeks after the settlement, the Pennsylvania Patient Safety Authority issued a formal advisory citing the Asante case, without using Claudette's name, as the basis for new mandatory disclosure requirements for surgical monitoring equipment failures. Any hospital in the state that received internal complaints about equipment malfunction was now required, within 30 days, to either remove the equipment or produce a documented safety review accessible to any affected patient's family. The advisory cited in its legal reasoning section Garrison v. Allegheny Health Network, and the supplemental discovery motion filed by Kwame Asante, next of kin advocate, case number 2023 CV04418. Beverly framed a copy and mailed it to him. It arrived on a Tuesday. Brianna was doing homework at the kitchen table when Kwame opened the envelope. She looked up, saw whatever was on his face, and didn't ask. She just slid her chair over and sat close to him while he read it. Their grandmother called from the kitchen to ask if they wanted dinner. Kwame folded the paper carefully and put it back in the envelope. Yeah, Grandma, he said. We're coming. He had walked into that first law firm lobby as a home health aide's son in a borrowed blazer, someone so easy to dismiss that the attorney hadn't even broken stride. He walked out of this as something the legal system in Pennsylvania had been forced to acknowledge in print, not because he had money or credentials or connections, because he had read everything, questioned everything, and refused to accept that a 17-minute silence in a log was the end of his mother's story. It wasn't. He had made sure of that.